lecture of this lecture series. So today we have with us the title of today's lecture is Adivasi and Indian Constitution, and today's speaker is Professor Nandini Sundar. She is Professor of Sociology at Delhi School of Economics, University of Delhi. Her recent publication includes The Burning Forest, India's War in the Bastar, which was published in 2019, which has been translated also in Gujarati, Tamil, and Telugu, and also 4 edited volumes, Reading India, Selection from Economic and Political Weekly, The Scheduled Tribes and Their India, which was published in Oxford University Press, Civil Wars in South Asia, State Sovereignty and Development, which came from the Sage publication, and Inequality and Social Mobility in Post-Reform India, the special issues of contemporary South Asia, as well as journal articles on democracy, authoritarian and academic freedom. Professor Nandini Sundar was awarded the M.N. Srinivas Memorial Prize and also Infosys Prize for Social Sciences. She also received the Easter Prize for Development Research in 2016, and also the Malcolm Prize for Distinguished Contribution in Development Studies 2017. The chair or moderator of today's lecture is Professor Jagannath Ambagudia. He is a professor at the Center for Peace and Conflict Studies, School of Social Sciences and Humanities, and also the chairperson of Unit for Research and Development, Tata Institute of Social Sciences, Guwahati campus, Assam. So welcome you both, ma'am and Professor Jagannath.
Thank you.
Now I invite Sukhdev Vishwapremi. He is an activist of Dalit rights and marginalized people. And he is working for SST Saplan movement in Himachal Pradesh. Recently, they started in big way. He is also working with the land development of poor people and sustainable agriculture. Formally, I request the Vishwapremi to welcome this meeting.
थैंक यू सभी का आज के इस संविधान के 75वें वर्षगांठ में स्वागत है। ये सीरीज संविधान के समालोचन के उपलक्ष्य में शुरू किया गया था। ये लेक्चर 2 सीरीज है और आज का जो विषय है, जैसा वर्मा जी ने कहा कि आदिवासी एंड द इंडियन कॉन्स्टिट्यूशन, इस विषय पर प्रोफेसर नंदिनी सुंदर जी हमारे बीच में बात रखेंगे और प्रोफेसर जगन्नाथ अम्बागुड़िया जी इसको मॉडरेट करेंगे। ये जो सीरीज देश भर में संविधान के प्रावधानों को लागू करवाने में काम कर रहे हैं, उनकी तरफ से शुरुआत की गई। इस प्रक्रिया में बहुत से ऑर्गेनाइजेशन जुड़ रहे हैं। सेंटर फॉर दलित स्टडीज ने इसकी शुरुआत करी इंडियन इंस्टीट्यूट ऑफ दलित स्टडीज के साथ मिलकर के। इसमें सेंटर फॉर दलित स्टडी, दलित राइट्स, सीडिया, नेशनल अलायंस फॉर सोशल जस्टिस, दलित कोलिशन जो नॉर्थ इंडिया में एक शुरुआत हुई है, और पीपल्स कैंपेन फॉर सोशियो-इकोनॉमिक इक्विटी। इसके अलावा और भी देश भर के बहुत से संगठन जो संवैधानिक प्रावधानों के मुद्दों पे काम कर रहे हैं देश भर में, वो इस प्रक्रिया में जुड़े हैं। और बहुत से जो प्रबुद्ध नागरिक जो समता मूलक समाज बनाने की दिशा में प्रयासरत हैं, वो इस प्रक्रिया में जुड़े हैं। तो आज के इस लेक्चर सीरीज 2 में आप सभी का स्वागत है और हम आदरणीय प्रोफेसर मीनाक्षी नंदिनी सुंदरम जी का स्वागत करते हैं कि वो इस शुरुआत करें आज के इसकी। इसी के साथ सबको जय भीम, जय बिरसा, जय संविधान, जय भारत। थैंक
तो जगन्नाथ, प्रोफेसर जगन्नाथ जी ने कुछ बात रख लीजिए। आफ्टर दैट नंदिनी सुंदर।
Okay, hi, good evening everyone, and it's pleased to be part of this lecture series, and of course the lecture is going to be delivered by Professor Nandini Sundar, who has worked significantly on various issues of tribal communities. Just before the meeting started, then there was an informal discussions considering the fact that they have the aim of having at least 75 lectures in the series of this one. That's a phenomenal initiative. I think since we are celebrating the 75th years of India's constitution and so on and so forth, it's also essential to revisit the kind of constitutional provisions that are there in relation to tribal communities. Uh, if we look at the provisions of Indian constitution, then there are a lot of series of ameliorative efforts that were taken to address the various issues and concerns of tribal communities. But my other concern is because this is, I think, one of the most uh, uh, the focused areas, because if you search on Google also considering the tribal communities, then probably will get series of articles as well as writings on the constitutional provisions of tribal communities. As Professor Nandini has already pointed out, that she will take us through quickly about the different connotations, different aspects of constitutional provisions and so on and so forth. But for me, I think the other concerns is not necessarily to look at the tribal issues within the ambit of India's constitution, but what kind of issues are raised at different platforms that are also required to be addressed. For instance, I think if you look at the position of tribal communities, and at certain point of time, Indian Institute of Dalit Studies had organized a conference on the positionality of various marginalized communities in academic scenario. And if you look at the position of tribal communities in academic scenario or university curriculum and so on and so forth, then there is hardly any attention that has been paid to the tribal communities of India. I'm a student of political science and I'm aware about the kind of position that has been given to tribal communities in the political science curriculum of some of the best universities of India, like JNU, Delhi University, Central University of Hyderabad, and other state or regional universities as well. So I think we also need to, it's not necessarily to look at the various provisions of India's constitution. Of course, that is important, because if you look at the various provisions of India's constitution, then the provisions themselves are contradictory in nature. If you look at the position or the various aspects that are aiming to address the tribal communities, of course, there is a need to revisit the constitutional provisions to address the inherent contradictions that are there in relation to tribal communities. But also, I think it's time to go beyond the constitutional provisions and look at what kind of awareness, what kind of sensitivity, what kind of commitment that have been created to address the issues and concerns of tribal communities at the larger level. I think with these few words, I'll request Professor Nandini to take the platform, and probably I'll again come back once she finishes her lecture. It's over to you, ma'am.
Thank you. How long do I have to speak?
Not sure. I think maybe half an hour or 45 minutes should work, if that is okay with the organizers.
Yeah. Okay. Thank you. Thank you, Professor Ambagudia, and thank you, Professor Lakshmaya, for inviting me. I'm really happy to be here to be part of this very important initiative to celebrate and analyze 75 years of the working of the Indian Constitution. And we see in the past few years how important the Constitution has become to all of us as a topic of discussion, precisely because it's under threat today from the powers that from those who are in power. So before I begin, I would actually just like to say Jai Bhim, Jai Johar, and thank you to everyone once again. When we talk of the Indian Constitution, there are 2 or 3 aspects that I would like to highlight. One is how, as far as the government goes, there is absolutely no observation of existing constitutional rights. So for them, the Constitution simply doesn't exist. It's whatever they say it is. So today, we have got reports from villages in Bastar of mortar shelling in several villages, Kondapalli, Rekapalli, Komadpalli, there are 6-7 villages in Bijapur district. And it's completely unconstitutional to be shelling your own people, to be bombing them in their villages. And yet, what has happened is that when people have protested against this, not only is it unconstitutional to be, bombing people, but when they are protesting, they have been declared, their organizations have been banned under the Chhattisgarh Special Security Act. So for the last 3 years, there have been very peaceful, non-violent dharnas by villagers themselves, organized under the banner of a movement called the Mulvasi Bachao Manch, which is led largely by local youth. And they have been demanding their rights under the Panchayat Extension to Scheduled Areas Act of 96 and the Forest Rights Act of 2006, saying that whenever anything happens in their villages, whether it's mines coming up or a security camp that comes up, the villagers should be consulted. And yet, this simple demand that if you're going to establish security camps, build highways, put in mines, have extractive mining industries, then you need to ask for villagers' permission. This simple demand by the villagers has been treated as something that is unlawful, and the Mulvasi Bachao Manch has been banned for openly protesting. Now, I can understand if you're banning people for doing underground activity, but you're now banning people for doing open mass constitutional activity. And that really is worrying, that the people are invoking the Constitution and the government is saying that the Constitution invoking the Constitution is unlawful. We saw the same thing with the Pathalgadi movement in Jharkhand, where people had inscribed provisions of the Constitution on huge stone pillars outside their village. And again, many of them were arrested and, the whole movement was repressed. So we see that on the one hand, there are various Adivasi movements that are invoking the Constitution. And on the other hand, when they invoke the Constitution, the government is treating that itself as an unlawful activity. So I think it's important to look at two things. One is how the Constitution was made. ये Constitution कैसे बना, किसने बनाया, Constituent Assembly में क्या-क्या discussion हुआ. It's important to look at the personalities who were involved in the making of the Constitution. The second is to look at the provisions, the official provisions of the Constitution and the unofficial provisions of the Constitution, because when it comes to Adivasis, there are many official positions, right? There are, firstly, we have Article 366 25, which describes scheduled tribes as those communities who are scheduled under Article 342. While Article 342 defines a scheduled tribe as a community which has been notified as such by the President. The lists are state-specific, so Santals and Mundas are a scheduled tribe in Jharkhand, but not in Assam or Andamans, where some of them had migrated or were taken as indentured labor. So you see, the official categorization itself is circular. There is no content to the definition of who is a scheduled tribe. It's whoever has been notified as such by the President. Then if you look at the formal constitutional provisions, we have on the one hand scheduled areas, which are in 9 states. Then there are lists of scheduled tribes, and it's not a perfect overlap because some states like West Bengal or Tamil Nadu have no scheduled areas, although they have scheduled tribes. You have Article 342, which is the power to schedule communities on a state-specific basis. Article 244, which provides for the 5th schedule in central India and 6th schedule in northeast India. Under the 5th schedule, there are laws against land alienation and money lending. And the idea is that laws that are applicable to the rest of the state will not necessarily be applicable to these areas. And the 6th schedule gives greater autonomy and greater self-governance. Now, under the 5th schedule, we have PESA and Panchayat Extension to Scheduled Areas Act, which says that whenever anything is, whenever any issue comes up in Adivasi lands or villages, then the village must be consulted. The Gram Sabha must be consulted. The Forest Rights Act recognizes a whole range of customary forest rights and historical injustice. We also have the Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act, 1989. And the government has also set up a Ministry of Tribal Affairs and a National Commission for Scheduled Tribes under Article 339. So all of these are protective legislation for scheduled tribes, which recognize that they are a self-governing, autonomous community at some level. Then we have provisions for reservations, which are similar to reservations for scheduled castes. And there is now an attempt by the BJP to say that people belonging to Christians or Muslim scheduled tribes should not qualify for reservation, which is a complete misunderstanding of the concept of how reservations are different in the case of scheduled tribes and scheduled castes. In the Constitution, although I completely disagree with this, the idea that the disability of scheduled castes came from religious disability, from the restrictions imposed by Hinduism, was used by a reason for restricting reservation for scheduled castes only to Hindu Dalits. Whereas for scheduled tribes, the reason for reservation was not because of stigma or discrimination within a religion, but because of economic backwardness of the whole region in which people could be of any religion, right? The scheduled tribes could be Christian, they could be Hindu, they could be Sarna Dharm, or they could be Adi Dharm, or whatever the Adivasi religion is. And in fact, the Constitution specifically, I mean, there are various laws which specifically say that scheduled tribes are not Hindu. So the Hindu Succession Act does not apply to scheduled tribes. So to say that Christian scheduled tribes should not get reservation is completely a mockery of the Constitution, and it's a very worrying trend that the RSS is trying to promote to whip up this kind of division between different Adivasi communities. So on the one hand, you have reservation, which is similar to reservation for scheduled castes, but it's on a completely different logic. So Article 15.4, Article 16.4, which enables reservation in government services, Article 275.1, which relates to central grants in aid to states for the specific purpose of scheduled tribe welfare, and Articles 330, 332, and 335, which stipulate seats for scheduled tribes in the parliament, state assemblies, and services. Now, if we were to look at just these provisions, you would think that the Indian Constitution has a lot of provisions for Adivasis and for scheduled castes, and that really, by the way the Constitution was designed, they were to have the first right over minorities and scheduled castes and scheduled tribes were to have the first right on resources. But if you look at the actual story told by statistics, we see that there is a 30% gap between the Human Development Index of scheduled tribes and the All India figure. About 45% of scheduled tribes are below the poverty line, according to the 2011 census, because that's the last census that we have, because this government is refusing to carry out the census. I mean, it's the first time for the last 150 years that we have not had a decennial census. And it's really shocking that you can have Kumbh Melas, you can have elections, you can have all sorts of things, but you can't have the census, which is essential for any kind of government program, essential for people to know what their, you know, status is on various indicators. The daily per capita consumption or expenditure of scheduled tribes is half that of the general category. Child mortality rates are highest among scheduled tribes. And what is most shocking is that about 46% of scheduled tribe women have a body mass index of less than 18.5, which is actually indicative of chronic starvation. So you see that on every indicator, health, न्यूट्रिशन, लोग आदिवासी लोग बहुत ही वंचित है, उनके रिसोर्सेज को छीना जा रहा है, और ये वंचित होने का कारण ये है कि लोग बैकवर्ड है या लेजी है या पीते हैं। जैसे सरकार, जब भी आप कहीं भी जाओगे तो जो बाहर के लोग आते हैं तो वो बोलते हैं कि ये लोग तो पीत के रहते हैं, उनको तो कुछ काम ही नहीं करना चाहिए, करना आता है, उनको काम करना ही नहीं है, इसीलिए तो वो इतना गरीब है, पिछड़े हैं, इलिटरेट है। ये सब is the government in a way explanation for poverty, whereas we know that the real explanation for poverty is basically the theft of people's resources. At the same time, we need to have a somewhat more differentiated picture because, for instance, Mizoram and Lakshadweep have the second and third highest literacy in India, and some communities are quite well represented in government service. But as such, the share in reservation, if you look at central universities, for instance, is much, and various other jobs, is much lesser than the share of the population. So on the one hand, you have provisions in the constitution which are supposedly beneficial for Adivasis. On the other hand, the real provisions which are designed to address Adivasis are those which are taking away their resources and taking away their land. So the provisions of the constitution that most affect Adivasis are the Land Acquisition Act, the Mines and Minerals Act, the Coal Bearing Areas Act, the Indian Penal Code, because the Indian Penal Code has been used in a major way against Adivasis. If you look at the number of people who are in prison out of proportion to their share of the population, we see Muslims, Dalits, and Adivasis. So the number of Muslim, Dalit, and Adivasi prisoners is much, much more than their share in the population, whereas the number of upper caste prisoners is much, much lower than their share of the population. So clearly, the judicial system is biased against these categories, and the police system is more likely to penalize or arrest these three communities. We also see that the language is alien to people. If you look at education, again, there is a difference between Adivasi and Dalit education because Adivasis have their own languages which are different from the state languages, and these you find very few school teachers who are really conversant with these languages. And recently the idea that in Andhra, that in Telangana, that you could have 100% reservation for scheduled tribes in scheduled areas was shot down. So the real provisions are really these anti-Adivasi colonial era acts, which have continued to exist despite the promise in the constitution. And this is represented in the figures of people displaced, the land alienation. If you see average operational land holdings have also fallen from about 2.5 hectares in 1980-81 to 1.5 hectares in 2010-11. So increasingly, Adivasis are being made landless and being forced to migrate, and the contemporary concerns that Adivasis face are landlessness, uncertain tenure. There's a huge demographic shift happening in many Adivasi areas where uh, not Bangladeshis, but people from other regions are coming in, taking over Adivasi area. Upper caste Hindus are taking over Adivasi land. And lack of forest rights, displacement, state repression, and militarism. As I said, Adivasis are hugely, disproportionately imprisoned, arrested, especially in areas where the government is militarizing. Like, for instance, in Bastar, there is one security personnel to every 9 villagers, to every 9 Adivasis. So that's a huge level of militarization. And there are security camps every 2 to 5 kilometers. So almost in every village, there is a security CRPF camp, which occupies, huge areas, cuts down a huge amount of trees, takes over people's cultivable land. So these are serious threats to everyday livelihood and well-being of people. And of course, education and health. So let me come now to why the Constitution has, in a sense, not been as effective as it could have been. And that the look at how the Constitution was made and why the provisions in the Constitution that could really have helped people were not taken up. And on the other hand, the provisions that we do have are very watered down provisions in the Constitution. Are you following me so far? Am I going too fast?
It seems fine.
Yeah, it's okay.
Yeah, it's very fine.
Okay. So if you look at the way that people talk about the making of the Constitution as far as scheduled tribes or Adivasis go, it's often said that there is a direct line between the colonial provisions of the Constitution, especially the Government of India Act of 1935, which created excluded and partially excluded areas. And that independence did not really bring about so much of a change in these provisions. So they basically continued colonial provisions. So let's look at the colonial provisions that were carried on in some fashion into the Constitution. The first is the Scheduled Districts Act of 1874. Now, this act was a reaction to various Adivasi rebellions, and it marked out areas which were exempt from the normal operation of the law, which would be governed by their own specific laws. So that's also the root of some provisions like the Chota Nagpur Tenancy Act, the Santhal Parganas Act, the Wilkinson Rules in Jharkhand, which are basically saying that these tenure laws are separate and distinct from the land laws or tenure laws that are applicable to the rest of the state of what was then Bihar. Then you had the Montague-Chelmsford Report of 1980, the Government of India Act of 1990, and the Government of India Act of 1935, which created excluded and partially excluded areas. So the excluded areas were in the northeast, and the partially excluded areas were to be governed. So this was, by then you already had, representative governments in various provinces, and it was in the partially excluded areas, the local government was to have some say, but the governor was to have a kind of veto power. And in the excluded areas, the governor was to have complete power. So this was a position before the Constitutional Assembly came into existence. Now, in 1946, the Cabinet Mission Plan, and this is very important. I want to read the full paragraph on which is relevant to the making of the constitutional provisions. So the Cabinet Mission Plan said, and I'm quoting, "The Advisory Committee on the Rights of Citizens, Minorities, and Tribal and Excluded Areas should contain full representation of the interests affected, and their function will be to report to the Union Constituent Assembly upon the list of fundamental rights, the clause for the protection of minorities, and a scheme for the administration of the tribal and excluded areas, and to advise whether these groups should be incorporated in the provincial group or union constitution." So please note that it said a scheme for the administration of the tribal and excluded areas, right? A scheme for the administration. Now, there were 3 committees that were set up in the Constitutional Assembly. One was the committee chaired by Gopinath Bordoloi to examine the tribal and excluded areas in Assam. The whole state was then Assam before it was broken up into the smaller states. Then there was a committee under Thakkar Bapa, A.V. Thakkar, to study the excluded. Would you like to put your mic off, whoever else is speaking? Okay. So there was a Thakkar Bapa committee, and the third committee was to consider the tribal areas in the Northwest Frontier Province. Now, if the Northwest Frontier Province had stayed and there had been no partition, then perhaps the situation with respect to tribes might have been somewhat different, because the communities of the Northwest Frontier Province were much stronger. And in fact, at that point, the governor was writing saying you cannot do anything without consulting the tribes there, and they will not be governed by Delhi, or you have to consult them. Similarly was the view that you have to consult, people in Northeast India before you can actually take out any provisions for them. So we often think that, one, in the academic literature on the making of the Constitution, there is one version by Granville Austin, who wrote a book on the making of the Indian Constitution, which is considered a classic. तो उसमें लिखा है कि जब संविधान बना था तो there were a few people who were, it was made by elites, and people really did not know what was going on at the time of the making of the Constitution. So it was these 300 people in the assembly who were all, deliberating, and they were keeping out all the bad things that were happening then, like partition, or it was just a cool place of deliberation. The other version is that an undemocratic, and Dr. Ambedkar also said that, democracy is a top-down dressing on the Indian soil, and people have to be taught democracy. So these were the 2 claims that were kind of common in the literature on the making of the Constitution, that it was isolated from public opinion, and people needed to be taught democracy. But if you see actually the making of the Constitution, we see that there were, even in these subcommittees to frame the 5th and 6th schedule, there was a huge engagement across the country, even from Adivasi groups. So you think in 1940s, 1946, when the Constitution was being made, even at that time, Adivasi groups were mobilized to put demands in front of the assembly to say that they wanted all sorts of things. They wanted more education, more health, better health services, scholarships, but also some people were talking about proportional representation, because That way, smaller Adivasi communities would get some recognition. And they wanted members of their communities to be co-opted into the advisory committee. But we see in two states, Jharkhand and Nagaland, that people were asking for separate statehood and asking for self-determination and autonomy. And the government at that time, or the members of the Constituent Assembly, were not willing to concede tribals' demands for autonomy, whether it was in Jharkhand or in Nagaland. So they insisted on seeing their task as creating a scheme for administration. तो ठक्कर बापा और जयपाल सिंह के बीच में यही लड़ाई थी कि जयपाल सिंह जो झारखंड आदिवासी महासभा के लीडर थे और बाद में झारखंड पार्टी के लीडर बन के कॉन्स्टिट्यूएंट असेंबली में जो आए, उनका कहना था कि हमें सेल्फ डिटर्मिनेशन मिलनी चाहिए, हमें अपना झारखंड का राज होना चाहिए जिसमें हम लोग डिसाइड करेंगे कि हमारे राज में क्या होगा। और ठक्कर बापा का कहना था, जो उनकी कमेटी के जो चेयरमैन थे, कि कॉन्स्टिट्यूएंट जो कैबिनेट मिशन प्लान में सिर्फ स्कीम फॉर एडमिनिस्ट्रेशन, तो उसमें स्टेटहुड की का कोई जिक्र नहीं है, उसमें आप सेल्फ डिटर्मिनेशन की बात नहीं कर सकते, आप सिर्फ एडमिनिस्ट्रेटिव प्रोविजंस की बात कर सकते हैं। तो जो झारखंड का डिमांड उठा था, तो झारखंड के बहुत सारे ग्रुप्स ने चिट्ठियां भेजी कॉन्स्टिट्यूएंट असेंबली को। तो एक एग्जांपल मैं दे रही हूँ, प्रिंट, इट्स अ मेमोरेंडम फ्रॉम द आदिवासी स्टूडेंट फेलोशिप छोटा नागपुर एंड संथाल परगनास। और वो कहते हैं, इंडिया इज मार्चिंग टुवर्ड्स डेमोक्रेसी, we will be the future free citizens of India. India will be teaching democracy to her children. We are the most democratic people on earth. We have maintained the principles and ideas of democracy from the beginning. What we require at present is protection from disrupting us into tribes and sub-tribes by the present government. This tendency is solely meant to disrupt the democratic Adivasis. In order to keep our identity, our self-entity, and for self-determination, we demand a separate province constituting Chota Nagpur Plateau, etc. By this, we will be able to protect our culture, history, civilization, and our very own existence for the service of India. We will be in the vanguard in the battlefield for India's freedom. Jai Jharkhand province. तो उनका कहना था कि हमें डेमोक्रेसी सिखाने की कोई ज़रूरत नहीं है, हम खुद ही दूसरे लोग को डेमोक्रेसी सिखाएंगे कि डेमोक्रेसी कैसे प्रिजर्व किया जाता है। और आप हमें, जैसे आप दूसरे स्टेट्स को रिकग्नाइज कर रहे हैं, तो हमें भी रिकग्नाइज कीजिए, क्योंकि गवर्नमेंट का एक्सक्यूज़ था कि यहाँ के भाषाएं अलग अलग भाषाएं हैं और ये लोग अलग अलग ट्राइब्स है, उनका एक कॉमन लैंग्वेज। जबकि आप देखें कि मैथिली, भोजपुरी, मगही, ये सारे भी तो काफ़ी अलग अलग डायलेक्ट्स है, भाषाएं हैं, पर फिर भी उनको स्टेटहुड दिया गया, यूपी को स्टेटहुड दिया गया कि एक हिंदी भाषा प्रोविंस है। तो झारखंड में ये नहीं रिकग्नाइज करके, ये एक्सक्यूज बना के कि आप अलग अलग भाषाएं बोलकर, ये आदिवासियों के साथ नाइंसाफी थी। तो एक तो इस टाइप का डिमांड आ रहा था झारखंड से। दूसरा, आप देखते हैं कि शिलोंग से, नागालैंड से भी ऐसे ही डिमांड्स आ रहे थे। फॉर इंस्टेंस, देयर इज अ टेलीग्राम फ्रॉम द प्रेसिडेंट ऑफ द खासी नेशनल दरबार saying hill tribes of northeast frontiers are totally unrepresented there. Mr. Nichols Roy, simply Congress nominee, not theirs, framing their own constitution, reserving right of secession from Hindustan. Pray publish. Mizo Union Working Committee ने भी लिखा कि the working committee feels with great concern that exclusion from representation in framing the Constitution of India means exclusion from the general life of India. It is therefore decided that if they are excluded from duties of framing the Constitution of India, they will make their own constitution according to their own model. The Working Committee of the Mizo Union wished to inform the present Constituent Assembly members that it would be a waste of time to frame the Constitution for Lushai people other than their own nominee. तो जो लड़ाई हो रही थी, एक तो बहुत सारे लोग बहुत सारे आदिवासी समाज अपना अपना representation भेज रहे थे. There was also an ongoing battle between Thakkar Bapa and Jaipal Singh. So Jaipal Singh was talking about the right of self-determination, whereas Thakkar Bapa was talking about simply an administrative scheme. When it came to debates on the sixth schedule, we find there is a lot of condescension, racism towards people in the Northeast. So, for instance, Brajeshwar Prasad, this is from debates on the sixth schedule. Brajeshwar Prasad, Bihar General, says, I may be confronted with the question, what will you say to the tribals if they come and tell you that they want political autonomy? I will never concede this demand. I believe in the principle of the greatest good of the greatest number. I will not jeopardize the interest of India at the altar of the tribals. Kuladhar Chaliha, Assam General. Nagas are a very primitive and simple people, and they have not forgotten their old ways of doing summary justice when they have a grievance against anyone. If you allow them to rule us or run the administration, it will be a negation of justice or administration. It will be something like anarchy. In the subsequent provisions of this schedule, you will find that an act of parliament cannot be imposed on them unless they consent to it. Have you ever heard that an act of parliament cannot be applicable to any people unless they agree to it? Actually, an act of parliament is supposed to be applicable to people if they agree. That is a democratic principle. It cannot be imposed on people without. But this kind of racism we see constantly when it comes to scheduled tribes. Rohini Kumar Chaudhary, when the ICS officers came to India, their first concern was to find out some territories in the province of Assam where there were no mosquitoes, no lawyers, and no public men. Do you want an assimilation of the tribal and non-tribal people, or do you want to keep them separate? If you want to keep them separate, they will combine with Tibet, Burma. They will never combine with the rest of India. You may take it from me. So this was one lot of people who wanted to deny Adivasis any right to self-representation, self-determination. On the other hand, there were a few voices like Reverend Nichols Roy, and I'm quoting, rather than expect the hill tribes of Assam to rise to the standards of plain Hindus, there are many respects in which the latter should emulate the former as being more civilized. For instance, in the level of equality that prevailed among them. Jaipal Singh says, one was the power solution, the other is the knowledge solution. The vehement language of some of our members inclines towards power solutions. They want to force the tribal people of Assam to do things against their wishes and expressed will. I suggest that is no solution at all. If you do that, you are certainly going to bring about what you fear. You're not going to obviate, but you're going to bring about a further disintegration of India. So if you impose things on the Nagas or Mizos, then you are actually going to create a problem. Now, to come back to this question of scheme for administration as against what people want, we find that there are three levels at which the provisions of the scheduled areas or fifth schedule really got watered down. On the one hand, first there was the advisory committee which toured different tribal areas and came up with some provisions. Then there was a drafting committee, and finally there was the assembly discussion itself. Now, one very important thing that happened was that when the advisory committee proposed a tribes advisory council, the idea was that the tribes advisory council would propose things for scheduled areas, and the governor would have to take up whatever the tribes advisory council proposed and look into it or act upon it. Now, the provision in the fifth schedule says that the governor will refer items to the tribes advisory council. So the tribes advisory council is only like a body which the governor consults. It's not an active body which can take up issues on its own. Then we have what Jaipal Singh had suggested was that for every scheduled area, there should be a separate budget which says how much is going in, how much is coming out. So we would have known how much exploitation is taking place from these areas and how much internal colonialism is happening economically. Now, that was also taken away. The idea was that they would be consulted, and again, K.M. Munshi, who was earlier with the Hindu Mahasabha, then became part of the Constituent Assembly, said that, we cannot be consulting Adivasis on every small thing, otherwise they will become miniature parliament, which is exactly what the idea was. So there were many provisions which were heavily watered down. And the final provision that we got in the Constitution, in the 5th schedule, was really, again, an administrative scheme for the protection of Adivasi interests in land and against money lending. So while Jaipal Singh, Nicholas Roy, Jaipal Singh kept asking for more representatives, more tribal representatives in the Constituent Assembly. The cabinet mission plan had said full representation, but there were only 6 members of the scheduled tribes in the Constituent Assembly. And apart from Jaipal Singh, the others really did not open their mouth and did not really do anything. So what we got was a very watered down version as against the vision that different movements, different people had for actual autonomy. Which is why right from 1948, when at the very time that the Constitution was coming into effect, we saw the first firing on Adivasis in Kharsavan in 1st Jan 1948. And it was a real tragedy that from 1948 till now, there have been so many firings on Adivasis simply for trying to protect their own resources, their own lands, and that even when they invoke these watered down provisions of the Constitution, they are being treated as unlawful. So Adivasis have struggled to create a constitution that meets their aspirations and have been struggling since 1946 and earlier till now. And yet they are constantly being treated as unlawful and unconstitutional. And so the Constitution is an object of ongoing struggle and ongoing aspiration. Thank you.
Okay. Thank you so much, Professor Nandini. And it was a very interesting lecture, which essentially took us through the various provisions of Indian Constitution, as well as the grounds under which the provisions related to tribal communities were debated in the Constituent Assembly. And also, I think it was very interesting that he focused on two of the most progressive legislation that we ever had in the parliamentary history of India, such as the PESA as well as FRA, which essentially empower the tribal communities. And also your lecture took us through through various legislative measures adopted by the successive governments and how these legislations have essentially put the tribal communities at the back step, in a sense that these legislations do have the potentiality of negative impact over tribal communities. I think what we'll do is we'll open this platform for question answer session also. What I'll request is that before asking questions, I'll request you to introduce yourself, and please try to be as shorter as possible so that we can accommodate more and more questions. The floor is open for question answer session now. Please unmute yourself, and if possible, put your video on also before raising any questions. I think Sankar Prasad Duria has the question. You can go ahead.
Thank you, each and everyone. It was very good presentation, my Professor Nandini Sundar. After a long time, I'm hearing a lecture by her. Madam, you spoke about Indian Constitution and tribal rights and many more things, but whenever we see in Indian context, the tribals are the worst victim of, particularly on industrialization, mining, wherever you go. I am from Kashipur and I am a civil rights activist. I was a student of political science in Delhi University. And my question is that how do you see the principle of welfare state policy in the recent scenario? Because in Indian constitution, many provisions are there, but the welfare state policy measures which should be applied in Indian state, particularly on tribals, that is not happening. I don't see the theory or the real principle of welfare state policy is doing in the Indian context. Thank you.
Okay, I think we can have some more questions so that she can respond to them collectively. Yeah, please go ahead. You need to unmute yourself if you have questions. You are on mute. You need to unmute yourself. I think with the name Bboard V2059.
Hello. Hello.
Yeah, now you're audible. Please go ahead.
Yeah. Sir, I am from Himachal Pradesh, engineer M.R. Dadoch. And here in Himachal Pradesh, there are no Adivasi area. Here the scheduled tribes area is there. So I want to know that what is the difference between scheduled tribes and Adivasis? As the madam said, no doubt there is a caste system in scheduled tribes areas in Himachal Pradesh, but is there any caste system in Adivasi? If it is this there, then what is the condition of the scheduled caste among the Adivasis? This is my question. And what about their demography and share in the public and the political system? Thank you very much.
Okay, thank you. Are there any more questions? I think Professor Nandini can respond to this question first, then we'll open up for next round of questions.
Good evening, sir.
Okay, please go
I am
ahead.
from Andhra Pradesh. Within the fifth schedule, I think Tribal Advisory Committee not established since 1950 January 26. So there is nothing loss or amended a para 5.1 amended nothing loss according to para 5.1, sir. Who is the responsible person to constitute constitutional machinery to provide fifth schedule, like members, appointing of members, how to function the tribal advisory committee, tribal advisory council. So there is no established constitutional machinery according fifth schedule, sir. Who is the person to establish it? This is my question, sir.
Okay, thank you. Now I think Professor Nandini can respond, then we'll open up for the next round.
So I'll start with the last question. So there is clearly no, I mean, the government has not, in many places, established tribes advisory councils. They have not. The governors are supposed to provide a report on the status of the scheduled tribes in their state, and they are not doing it. There is really, just as with every aspect of the Constitution, it's not any one person who can ensure that the Constitution is being upheld. It has to be, we have to keep highlighting how even these weak provisions are being violated. So in fact, at the time of the Constitution, although Dr. Ambedkar recognized that the governor was only a nominal head and really didn't have any separate powers. At the same time, the Constituent Assembly went ahead and gave the governor powers in fifth schedule areas, saying that they are responsible for the maintenance of peace and welfare and of scheduled tribes. So that was a huge mistake, because on the one hand, if you know that the governor is only going to be carrying out the policies of the whichever party is in power, and you expect that governor to do anything for scheduled tribes and to take independent decisions, or you expect the president to take independent decisions, is really, it's in a way a farce. The whole structure was set up as a farce. So I think that was certainly not something that was designed not to work, because the governor and the president have powers to do something for the welfare of the scheduled tribes. Secondly, in terms of the welfare state, while as I said, there are so many constitutional provisions for reservation, for tribal subplan. In fact, if you look at if you do an economic costing of the resources that come out of tribal areas, whether it's mines or forest produce or whatever, and what goes in, we'll find that what comes out is much, much more than, and Dr. Ambagudia has also worked on this issue, right? That there is a lot of internal colonialism as far as Adivasi area goes. So the welfare state model of the government in scheduled tribe areas is really of mining, highways. It's not about, more irrigation, sustainable livelihoods. There's a whole warped development model which is anti-welfare. It's anti-people's welfare. So, security camps, highways, mining, that's not a welfare state. That's a military state. It's completely anti-people's welfare. The third thing, as to Himachal, there is Lahaul and Spiti have scheduled tribes. And in the Constituent Assembly, Jaipal Singh had said we should have Adivasis. That's how we call ourselves. That's what we understand ourselves. But at that point, it was decided that they would be called Janjatis, and Dr. Ambedkar said that they should be called scheduled tribes, because the schedule provides a exact list of who is a scheduled tribe. So Adivasis, he says, is not a sufficiently precise term that could be included in the constitution. So Adivasi is what people call themselves, like they call themselves Dalit, whereas in the constitution they call them scheduled castes and scheduled tribes. And people in the Northeast don't call themselves Adivasis, they call themselves scheduled tribe or whatever people they are. And in some ways, by not recognizing, by having a category of scheduled tribe, people's existence as nationalities or people is being taken away from them. Again, it's reduced to an administrative scheme rather than large areas which deserve self-determination within the framework of the Indian Constitution. So as for the caste system, yes, of course, there is a caste system. There is caste system among Muslims, Christians, Adivasis, everybody. In this country, you cannot escape the caste system. And there is, hierarchy everywhere.
Okay, thank you. Now I think we can go for second round of question and answer sessions if there are any.
Good evening, sir.
Hi, good evening. Please go ahead. Please introduce yourself first.
Yes, sir. Sir, my name is Guwahati. I am from Sundar district of Odisha, from Raurkela. सर मेरा ये क्वेश्चन है कि जैसे हम लोग का सुंदरगढ़ एरिया में कोयडा ब्लॉक है, इसमें हम लोग का जो एमएलए हैं सीपीआईएम के, वो 20 साल से एक ही सरपंच है, उनके हाथ में ही माइनिंग का है, माइनिंग भी है, फिर गवर्नमेंट एजेंसी भी है, तो जितने भी लेबर हैं वहाँ के सभी को उनका अंडर में ही रखे हैं। तो जो माइनिंग या जो एमएलए जिस तरह बोलेंगे कि इनको वोट देना है वही उनको वोट देंगे। तो 20 साल से 25 साल से वही एक ही एमएलए है। तो अभी जैसे अभी पत्थरगढ़ी का पैसा का जो आया तो उसमें बहुत सारे लोग उसमें जो लेबर काम कर रहे थे वो लोग उस पैसा को लागू करने के लिए उसमें जुट गए। तो जिसमें 200-300 लेबर हैं उनको उस कंपनी से निकाल दिया है। जो काम कर रहे थे लेबर उसमें से निकाल दिया है और उसको काम भी नहीं दे रहा है। तो अभी वो लोग का उनका स्थिति बहुत खराब है। तो सर मेरा ये क्वेश्चन है कि जो उनको जो 200-300 फार्मर हैं जो लेबर हैं उनको निकाल दिया है तो उनका कुछ फिर से क्या कोशिश हो पाएगा कि हम उनको कुछ करके हम उनको काम में फिर दिलवा पाएंगे उस माइनिंग एरिया से लेबर का। और इसके वाला जो अभी हम लोग का उड़ीसा में जो सीएम अनाउंस किया है कि पैसा रूल लागू लागू होगा बोल के, तो उसका कैसे हम यूटिलाइज करके उनको जो 200-300 लेबर हैं जो निकाल दिया है अभी, जो 20 साल से काम कर रहे थे वो लोग, तो उनको निकाल दिया, अभी उनको कुछ काम नहीं दे रहा अभी। और ऐसा हो रहा है कि आदिवासी आदिवासी में ही झगड़ा लड़ाई करवा रहे हैं। सर, यही मेरा क्वेश्चन है। थैंक यू सर।
Okay, I think we can have some more questions. Are there any other questions? I think you are still on mute. If you have any question, you need to unmute yourself. From Himachal Pradesh.
Sir, I am from Himachal Pradesh, Engineer M.R. Dhruv. My supplementary question again, that as Madam said, that Adivasis are Dalits. All are Dalits. This is my really in the addition in my knowledge. But
No, I didn't say Adivasis are Dalits. I said that
Yes.
just like Dalits are called scheduled castes in the constitution, they are not called Dalits. Adivasis are called scheduled tribes.
My question was that there is a caste system among Adivasis, and what is the caste system in the Adivasis? If there are scheduled caste among the Adivasis, what is the plight of those people? They are in the Adivasis.
Okay, I think we'll have some more questions then.
Okay. My question is, what is PESA Act, as you said? If it is autonomous and you say powers are vested to the local panchayats, then SCs living over there, are they the part of the PESA Act? This is my question.
Okay, sir, we got your question. Let's have question from some others also.
Thank you.
If there are any other questions. Okay, I think Professor Nandini, you can respond.
Okay, if you look at Adivasi areas, it's not as if only Adivasis live there. There are other communities. There are Dalits, there are scheduled castes, there are OBCs, there are Rauts. I mean, for instance, that is why, say, for instance, in Bastar, they have called their movement the Moolvasi Bachao Manch, because these are all Moolvasi communities who have been living together in these villages for a long time. And you go to any Adivasi area, you'll find Dalits. Odisha also, there is, Panos, there is Adivasi. It depends from area to area. So it's not as if these communities are not represented in the Gram Sabha. The Gram Sabha is for whoever is living in that village, and it is a body of that village which should be consulted under Panchayat Extension to Scheduled Areas Act. So yes, there is discrimination against Dalits in some Adivasi areas. But there is also some discrimination by Dalits against Adivasis where they have become more educated. So it's a very complicated thing that depends from place to place. There is no one answer to this question. As for what was the other question? Sorry, I forgot now.
The other question was related to Odisha, that some people are working in.
Yeah. That sounds a very difficult situation. And yes, whenever mining companies come in, they buy off some people, they employ some people, then other people are protesting against the mines. So it's a very common problem everywhere that um, mining companies introduce a lot of divisions among people. And as for this people being removed from employment, I don't know how you will do the local struggle. That is, I mean, I have no answer to that.
I'm Lakshmaya. Your case in Supreme Court about Salva Judum, it's a judgment. I think it's a very unique and important judgment in the Supreme Court. What is the relief with the judgment? One thing. Second thing is, what is the unique of that judgment? Is there any constitutional importance you found with that judgment? I think that judgment is in my one relief from these all those pressure measures by the governments. I think constitution, some areas sometimes it's provided some good things. So in that it's a Salva Judum case also one of the case I found. In my opinion, please respond.
So Salvajudum judgment was a very good judgment by
Ma'am, if it is okay, then we can invite two more last two more questions, then you can respond collectively. If there are any questions, then we can have two more so that we can finish this on time also. I think please go ahead, ma'am. I think there are no.
So Justice Reddy and Justice Nijjar gave us a very good judgment on Salvajudum. But unfortunately, the government of Chhattisgarh completely violated that judgment. So that judgment was saying two things. One is that it was based on fraternity and invoked Article 14 and 21, equality and right to life. And it said that, so what the government of Chhattisgarh had been doing was using surrendered Naxalites and forcing them to join the security forces as special police officers. And because they were surrendered Naxalites, the idea was that they would be able to find out the Naxalites and be more effective. But they were also motivated by feelings of guilt, by revenge. So they are actually the ones responsible for the maximum human rights abuses. And the judgment had said that because more SPOs were dying in the fight, in the frontline battle against Maoists, their right to life was being compromised, and their right to equality, as well as the right to life of the villagers who were being affected by this Salvajudum and SPOs. So they said that SPOs cannot be used in any form under any name in anti-Maoist frontline operations. Now, government of Chhattisgarh passed an act saying that all the existing SPOs would be converted into armed auxiliary forces from the date of the judgment. So basically, it's a slap on the face of the Chhattisgarh of the Supreme Court, saying that we are going to ignore your act, and they gave them more money, better guns. And so the beneficiaries of this whole exercise were the SPOs, the ones who they were supposed to be banned. And now the government has renamed them as District Reserve Guard, and they are again the same surrendered Naxalites who, they don't get any training in anything. They're just again sent off to fight. And the cases against them are also not dropped. So if you're a surrendered Naxalite or a arrested Naxalite, you will continue to have the same cases against you. But you continue to, now you are operating on the side of the government. So so those who are operating on the side of the government are in fact people with cases against them. So that is itself unlawful. Secondly, it's against the constitutional, it's against this Salvajudum judgment. And we filed a contempt case in 2012, and it has still not been heard. We are now still waiting for a date. Again, after 5 years, the case was not getting any dates at all. Now, again, they've started giving us some dates. But Chhattisgarh government is just, they have the cheek to come to court and give an affidavit saying that we are observing the the Supreme Court judgment and not we have disbanded all the SPOs, whereas the act which they have passed is armed auxiliary force, and it says very clearly for frontline operations. So Chhattisgarh government is in complete contempt. It has completely openly displayed its contempt for the Supreme Court, and yet the court has not taken up this contempt of court hearing for so long. And the other thing is that we kept asking for a monitoring committee which would go into all the cases of human rights violations. Now, every day, this year alone, in 24, over 250 people or something have been killed. Now, each time, how can anyone? So there has to be some kind of monitoring committee which will look into all these cases, because many of them are of ordinary villagers who have been killed, passing them off as Maoists. Just now, there's one case, one Pandu who was 18-year-old Pandu who was working in his field, and he was killed and body dressed up as Naxalite and shown as killed. So how can you expect villagers to keep going, and who are they going to approach? Nobody will file an FIR. On the contrary, they are all being arrested even if they try and go and ask about what is happening. And that we have not got. We have not got this monitoring committee, even though we have been begging for it from 2007. So what sort of a justice system is it that hundreds and hundreds of people will die while your cases are going on? And a simple thing like a monitoring committee that they could have given, they didn't give us. And as for the judgment itself, the Chhattisgarh government has shown that it really couldn't care less, and they're continuing with the same DRG. So I'm
Okay.
really disappointed in the judicial system. I mean, Justice Reddy and Justice Nijjar gave us a great judgment, but the lack of implementation is something that is really quite shocking.
Thank you.
Okay, thank you so much, ma'am. I think now I think we can end up this question answer session, and it was wonderful to listen to you, ma'am. And the participants also raise very interesting issues, and it's not like self-promotion kind of thing, but Professor Vajnesh Kaka and I have edited a book called Handbook of Travel Politics in India, and most of the issues that you have raised are also addressed in various chapters, including the Himachal Pradesh. If I remember, then this caste issue also being addressed in the chapter on Himachal Pradesh. So this book covers almost all states of India where the tribal communities are residing. It's called Handbook of Travel Politics in India. So the issue that Professor Nandini has raised essentially, enable us to revisit our position also on the position of tribal communities in Indian Constitution. So thank you so much for this wonderful lectures. Now I'll hand over this platform to the organizer. Thank you so much. Thank you.
Sir, thank you, Jagannath ji. Thank you, Nandini Sundar. Thank you, Sukhdev Vishwapremi ji. It's a eye-opening so many things, but we have to continue these issues. I think we are thinking every subject, tribal subject, also we can have another 2-3 lectures in different issues. Please suggest us which subject, which topic is good apart from this. Then like Dalits, women, the economic front, education, health, all those things, we are going to the 75 lectures. It's not a small issue. We have to pick up the resource persons like you and I. Our request is to suggest some name, some topic. It's very useful to conduct in good manner. Thank you to all.
Thank you.
Thank you. Thank you.